So the Supreme Court just issued a 9-0 unanimous decision, and that decision creates some concerns about future challenges to states when they pass unconstitutional rifle and magazine bans. So let's talk about what just happened. But real quick before we jump into this video, I want to mention that about 60% of all my viewers on the channel are actually not subscribed to the channel. So if you guys want to support this content, if you want this type of content and information to get out to more people, please consider subscribing to the channel, and that really does help the channel to grow and for this information to get out to more people. As I mentioned in the intro, we need to talk about an important 9-0 unanimous decision that was just recently issued by the Supreme Court. This decision by the Supreme Court has broad-reaching implications for a lot of state laws, including rifle and magazine bans that have unconstitutional mandatory confiscation provisions that are included in those laws. The case we're going to be talking about in this video is the de Villiers versus the state of Texas lawsuit. This case involves when individuals can sue a state directly because of an unconstitutional taking in violation of the Fifth Amendment's taking clause. The taking clause is something that we see pop up quite a bit in 2A cases, specifically when cases involve challenges to statewide rifle and magazine bans. Oftentimes, those state laws have confiscation provisions that are challenged essentially as unconstitutional and as unconstitutional because of a taking by the government and a taking without just compensation. Now, they're also often challenged under Second Amendment grounds, but takings clause is another thing that is often tacked on to those lawsuits. We have seen in cases like the Duncan California magazine ban case that courts dismissed those claims because they believe they're invalid. This case essentially sought clarification from the Supreme Court on whether the takings clause in the Fifth Amendment is self-executing to the point where individuals did not need express congressional authorization to sue a state in federal courts. In this case, the Supreme Court avoided that issue once again, and it creates a lot of issues and some potential fallout going forward in other cases, including 2A cases, when the takings clause is brought up. Now, I need to give you guys some context and some background on what this case involves so you understand what is implicated and what could happen going forward. This case arises out of the state of Texas installing a roughly 3-foot tall barrier along a highway median, essentially to act as a dam and prevent stormwater from covering specific areas of that road, and that was in the Houston area. In August of 2017, Hurricane Harvey brought heavy rainfall in that area, and that new median barrier that was put in place by the state of Texas essentially performed as intended, but then as a result, it flooded the petitioners and the plaintiffs in this case's land in a northbound area of Houston, and essentially it flooded their homes, damaged some of their businesses, ruined their crops, killed some of their livestock, and then just generally damaged some of the property where the water was flooded into. The same thing happened during a tropical storm back in 2019, and in response, 120 individuals impacted by that barrier that was put in place sued the state of Texas. Now, de Villiers, he was one of the plaintiffs. He's the named plaintiff in this lawsuit in the consolidated lawsuits, and they filed a lawsuit in the state of Texas court. So this was originally brought in a state of Texas court. He alleged that by building that median barrier and then using his property as a kind of overflow area, the state of Texas had effected a taking of his property. Now, de Villiers argued that he was therefore entitled to just compensation under both the United States and the state of Texas constitutions, pointing there to the takings clause both in the U.S. Constitution and then under the state of Texas Constitution as well. And in result, the state of Texas itself, who's the defendant, filed a motion to remove that case from the state courtroom to a federal courtroom, and that's exactly what happened. But once the case was removed from the state court to the federal court, well, then the state of Texas argued that the case needed to be dismissed because there was no valid takings clause argument, that the takings clause did not allow these plaintiffs to sue the state of Texas in a federal courtroom. The state of Texas contended that only certain federal statutes provide a vehicle to essentially assert constitutional violations, and that those do not authorize claims directly against the state of Texas. Now, the plaintiffs there did not dispute that they intended to bring the federal lawsuit and the claim directly under the Fifth Amendment. Instead, him and the other plaintiffs responded that the takings clause is self-executing, which he argued means that the takings clause itself provides a cause of action for just compensation against a state like Texas. Now, on review, the federal district court denied the state of Texas' motion to dismiss the case and to dismiss the takings clause arguments that were brought. The court found that a property owner, like the plaintiffs here, may sue a state like Texas directly under the takings clause, that it was in some ways self-operating. Essentially, think of it this way. The state of Texas built a barrier and it resulted in flooding and damage of the plaintiff's property. So they sued the state of Texas in a state courtroom. Well, the state of Texas then decided to get the case moved from a state court to a federal court. Then ultimately what they argued is that the lawsuit could not move forward because now suddenly it was in a federal courtroom and the takings clause was not valid for this type of lawsuit in a federal courtroom. The state of Texas claimed that the takings clause is not self-executing and as a result does not permit the property owners to bring a case in federal courts even in absence of a specific federal statute authorizing a lawsuit. But in the lower court, the state of Texas lost, but then the state of Texas appealed up to the Fifth Circuit Court of Appeals. And in a one-paragraph opinion, the Fifth Circuit held that the Fifth Amendment takings clause as applied to the states through the 14th Amendment does not provide a right of action for takings claims against a state. That means that the Fifth Circuit believed that the takings clause is not self-executing and that a state like Texas could not be sued in federal court for a takings essentially outside of express congressional authorization or unless Congress expressly includes in a statute some sort of cause of action. That, of course, is absurd, and the plaintiffs immediately filed for Supreme Court review. The Supreme Court then granted review to the case and recently issued a 9-0 unanimous decision which vacated that Fifth Circuit decision and remanded the case back down to the lower court for reconsideration in light of what they said. However, the decision by the Supreme Court avoided the big question in the case and ultimately opens the door for even more issues and concerns going forward when it comes to the takings clause. The Supreme Court punted on addressing the issue of whether the takings clause is in fact self-executing to the point where plaintiffs can bring direct federal lawsuits against a state because of an unconstitutional taking without just compensation. In the decision, the court stated that our precedents do not cleanly answer the question whether a plaintiff has a cause of action arising directly under the takings clause. But this case does not require us to resolve that question. The question presented asks, what would happen if a property owner had no cause of action to vindicate his right under the takings clause? It would be imprudent to decide that question without satisfying ourselves of the premise that there is no cause of action. The premise that Texas left de Villiers and the other plaintiffs with no cause of action to obtain the just compensation guaranteed by the takings clause does not hold. Texas state law provides a cause of action by which property owners may seek just compensation against the state of Texas. As Texas explained at oral argument, its state law, inverse condemnation cause of action, provides a vehicle for takings claims based on both the Texas Constitution and the takings clause. And although Texas asserted that proceeding under the state law, cause of action would require an amendment to the complaint, it also assured the court that it would not oppose any attempt by the plaintiffs and the other petitioners to seek one. This case, therefore, does not present the circumstances in which a property owner has no cause of action to seek just compensation. On remand, de Villiers and the other property owners should be permitted to pursue their claims under the takings clause through the cause of action available under the Texas laws. Now, ultimately what this means is the Supreme Court did overturn the clearly incorrect Fifth Circuit ruling, which dismissed the plaintiff's takings claims and dismissed that case. That also means that the Supreme Court nullified the state of Texas' attempt to get rid of this case by simply moving it from a state court to a federal court. But there are still a ton of questions going forward with this case and other cases. Can the plaintiffs proceed forward in federal court with the state cause of action, or does it have to go back to the state of Texas court? And if it does go back to a state court, what then prevents the state of Texas from once again asking for the case to be removed from the state court, send it back to the federal court, and then just do a whole merry-go-round system where constantly they're getting this case dismissed and there's a lot of questions continuing to be brought up and this question about self-executing takings clause never actually being answered. Now you may be asking, how does this impact the Second Amendment in two-way cases? Well, plenty of times rifle and magazine bans include challenges to state laws under the concept that there is an unconstitutional taking and that there was never any just compensation. Most of the major two-way cases are often filed in federal courts. They're filed in federal courts because of Second Amendment violations, but also sometimes takings clause issues are raised as well. For example, the Duncan, California magazine ban case had both a two-way claim and then a takings clause claim. The takings clause often is related to the confiscation or the forced destruction of those items without any compensation by the government. But because of this case and this decision and the unclear status of self-executing takings clause, states like California and others can continue to argue that these claims should be dismissed. When it comes to takings clause and these types of claims into a case, it's already kind of been a hard argument to win. Sometimes district courts will rule in your favor, but oftentimes these forced confiscations and forced destructions of firearms and items, oftentimes the courts don't believe that's enough to actually warrant compensation by the government or to find a violation of the takings clause. Sometimes they'll say, well, you had other, avenues to you could modify, you could register, do all these other things, and therefore there was no takings clause violation. So it's already been an uphill battle when it comes to these types of arguments. But then you add this on top with the procedural aspect, and it makes it procedurally even harder going forward. So really an interesting case, and it will be interesting to see how this moves forward. Hopefully you guys found this video helpful and informative. If you guys have any questions, go ahead and comment down below, and I will try to answer to the best of my ability. Also, if you guys like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.